Going to do our video lecture on our last chapter this semester, the federal court system. So in this chapter, we're just going to look at the judiciary, what its role is as one of the three big branches of government. And, for the most part, people are somewhat familiar with what the judiciary does, but we'll kind of go into a little more detail than most people seem to know. So our legal system in the United States, we divide the law into two types. We have criminal law, which is the one that most people are familiar with. This is the branch of the law that regulates conduct of individuals, defines what crimes are, and specifies how people should be punished. In most cases, this type of law is handled by the state governments. Criminal law at the federal level really only comes into play when we're talking about crimes that have cross state boundaries. So those are usually big crimes, things like trafficking drugs or conspiracy to commit crimes, organized crime, financial crimes, things like that, because those very easily cross state boundaries. But for the most part, the day-to-day criminal law is the responsibility of the states. And then we have civil law, which can start at the state level or can take place at the federal court level. But civil law deals with disputes that don't involve crimes. This can be lawsuits, family disputes, territory disputes between states, all that kind of stuff. And so that's what most of federal law deals with. And we'll talk about how things get up to the top level, which is the Supreme Court. In most of our cases, we'll have a plaintiff, which is the person that is bringing the complaint, the person that has been wronged, or in the case of a crime, the plaintiff will usually be the representative of government. They're the ones that are bringing charges against an individual. The defendant is the one who the complaint is being brought against, whether it is someone who has committed a crime or a civil complaint like a lawsuit or something like that. Our court system relies heavily on precedents to make their decisions. So in the past, there are, previous decisions that justices will look at to see if have the principles of a previous case settled this type of dispute before, or can we use those principles to decide a similar type of case? So that's what we mean by precedent. And then sometimes a court will not hear a case. They essentially will let the previous ruling stand. So cases will start at a lower level, typically in the states. And as cases are appealed, they can work their way up to state Supreme Courts and then into the federal court system. But if the higher court believes that the lower court made the right decision, they'll rely on a principle called stare decisis, which means let the decision stand. The lower court got the question right. But that doesn't mean that the plaintiff or the defendant cannot appeal that decision. All right, so in our court system, we have three main types of courts that we're going to look at. The trial court is the one that most people are familiar with. This is where we go full out. We have testimony, witnesses, evidence, documentation, all of that kind of stuff. And that happens in both criminal and civil cases. We use different standards in those, though. When you take state government, we'll talk a lot more about the criminal justice system. But in a criminal case, we use the beyond a reasonable doubt to determine whether someone is guilty. In a civil case, we use what is called the preponderance of evidence, or whichever side has the most compelling evidence to support their claim. That's typically who wins. The Court of Appeals is when you don't like the decision you've gotten from the original court or in the trial court, you can appeal that decision to a higher court. But once you get into the appeal system, there aren't new trials. Essentially, the next court is just going to look at the circumstances of the trial to see if there were any miscarriages of the law, were people's constitutional rights respected, due process, and things like that, or is there any new evidence that could change the outcome of that case? So, usually, a panel of judges in the appeals court will review briefs that have been submitted by the attorneys and make a decision. Sometimes they can uphold a lower court's decision. Sometimes they can overturn a previous court's decision, or sometimes they can order it back to the lower court and order a new trial, especially in an instance where there is new evidence that could change the decision of the judge or a new jury. And then we refer to our Supreme Court, the U.S. Supreme Court, as the court of last resort, meaning that when the Supreme Court issues a ruling, that's it. There's no higher court in the United States than the Supreme Court. The states have state Supreme Courts as well, but they're not the end of the appeal system. You can appeal a case out of state court into the federal court system if the case meets certain constitutional criteria. So those are our three main types of courts that we really look at when we're talking about federal cases. Now, for criminal cases in our country today, 95% of our criminal cases will be decided through a plea bargain. A plea bargain, if you've ever watched any of these law dramas like Law and Order and stuff like that, you are probably somewhat familiar with some of this, but a plea bargain is essentially a negotiated agreement where the person who's been charged is agreeing to plead guilty to the crime in exchange for being offered a lower sentence. Now, this happens a lot in our country, and the reason why is that our court systems are very overwhelmed. On average, in most state court systems, you may wait 2 years to get a trial, and that costs money. You have to pay your attorney to retain your attorney, and you have to pay bail and all that kind of stuff. And the average American citizen does not have the money for all of this. And so, sadly, many people will take a plea bargain even when they are innocent, simply because they don't want to take the chance of getting a more severe punishment and they can't afford adequate legal representation. We know that the Sixth Amendment guarantees everybody an attorney. The problem is that it doesn't guarantee us a good attorney. Those who get the best outcome in our justice system are those who can afford to pay for the best legal representation, and that's a sad situation in our country, and why many people advocate for judicial reform. When we talk about the jurisdiction of a court, the jurisdiction is just what authority does this court have to hear this case. In our country, most jurisdiction is determined by location. So in our state courts, if you commit a crime in Tarrant County has jurisdiction over your case. Now, when we're talking about the federal court system, these are a little different. And we're going to look at the United States Supreme Court. Original jurisdiction is the authority to hear a case for the first time. There's not many instances where the Supreme Court will have original jurisdiction, but there are 4 examples where they do. 1, a case is between the U.S. government and one of the states. Only the Supreme Court can settle that dispute because both sides of the case are government. And so the Supreme Court, being the highest court in the country, is the only court that can settle that dispute. 2, the case is between 2 states. States can sue each other, and they have quite a bit in the past. And this can, pertain to everything from states not recognizing decisions in other states to territory disputes to any of that kind of stuff. And so since we're dealing with 2 states, one state's judicial system cannot exert authority over another. So only the Supreme Court can settle this dispute because it is higher than the authority of both of those state governments. Three, the case involves a foreign authority. So let's say a foreign country or a foreign dignitary or someone like that, or a foreign business wants to sue someone in the United States, a United States citizen, corporation, state, or the U.S. government. Only the Supreme Court has the authority to oversee that case because we are dealing with the authority of a foreign country outside of the jurisdiction of the United States. And then four, a case is brought by one state against citizens of another state or country. So again, when we're dealing with those high levels of authority, only the Supreme Court can have original jurisdiction to settle these issues. Now, anything outside of those four examples, original jurisdiction will probably be with the states or local government. But these are the four instances where a case will go straight to the United States Supreme Court. We talked about due process when we did our chapter on the Bill of Rights. And due process is just that guarantee that every individual should be treated fairly by our court system and is entitled to the protections of the United States Constitution. Due process protects us from arbitrary discrimination in the court system. Now, this is the underlying principle about our justice system that is created by the Constitution, but we are not naive, and we know that our country has had and still has problems with living up to this principle. In the past, people have been discriminated against in our judicial system, whether it was based on their race, their religion, their sexuality, things like that. And through the process of the evolution of our government and the evolution of our judicial system, we've tried to take those discrimination. We've tried to take that discrimination out of the legal system, but we know that our legal system is not fair, and unfortunately, it is not cheap. And so, there's a lot of debate over whether our legal system really still lives up to these principles, and what we still need to change today to make the legal system as fair as possible. If you look over here on the left, this is Lady Justice. She is the kind of icon for the justice system that we use. And if you look at her, there's a lot of symbology in her appearance. She wears a blindfold, which is telling us that justice is blind. She's not supposed to see the people or judge the people based on their appearance or their whatever arbitrary categories they fit into. It's just supposed to be based on evidence, and that's what the scales represent. We take the evidence of one side, the evidence of the other side, and weigh it against each other, and that is how we make decisions. And then, of course, she carries a sword, which represents the judiciary's ability to punish people who have broken the law. So that's kind of the symbology behind Lady Justice, and you see her in courtrooms and things like that all the time. Now, habeas corpus. This is in our Constitution, the idea that when an individual appears before a court, habeas corpus is a Latin phrase, and it translates to "show me the body," which what we mean by that is show me the evidence. What is the evidence that this person has committed a crime? And so when a person is brought before a court, they have to be informed of why they are being detained. They have to have been read their rights, especially their Miranda rights, and understand their due process rights. One of the more controversial things that's happened in our history is Abraham Lincoln actually suspended habeas corpus during the Civil War. And so when the United States apprehended people who were fighting for the Confederacy, Lincoln's view was that they were no longer entitled to due process because they were basically traitors to the country of the United States. So, during times of war and times of crisis, sometimes we'll tolerate our president or our Congress, kind of undermining these protections of the Constitution. But there's always that debate, especially, when we're talking about the Civil War, as to whether Confederates were citizens of the United States, and we still debate today whether people who are not citizens of the United States but are in our legal system are entitled to the same protections. The Constitution, the way it's been interpreted, is that it does apply to anyone in the United States, whether they are a citizen or not. So, one of the areas where this has been controversial today uh, is the detainees in Guantanamo Bay. When we went to war in Afghanistan and Iraq, we have detained people who are suspected of terrorism or associated with people who are suspected of terrorism, and we've essentially detained them indefinitely in Guantanamo Bay. There are people there who have been detained there since 2001, 2002, who have never been given a trial, who have never been charged with a crime, but we say that we can't release them because it's too dangerous to release them because they are terrorists. This kind of goes against the idea of the Constitution. The idea behind due process is that everyone should be charged with a crime and stand trial in our system, whether they are an enemy combatant from another country or whether they are an American citizen. Now, the federal court system is divided into different districts, and that's what this map is over here. You can see all the districts 1 through 11. And so if there's a federal case that occurs within the states of that district, that district's federal courts will hear the case. And so you get different rulings kind of depending where you are in the country, because the judges for those federal courts usually kind of reflect the views of where their district is located and are usually appointed from are judges appointed from within those states. So if you say are arguing a case in District 5 or District 11, those tend to be the most conservative districts in the United States. And if you say are arguing a case in District 9 or District 2, those tend to be more liberal because, you've got California and New York. So, that's why you'll see different rulings over different issues, and then it's up to the Supreme Court to settle those disputes. But within our district court system, we have 678 judges serving in 94 different district courts. And they hear cases when the federal government has jurisdiction. At this level, we typically have a panel of judges. So usually it's 3 judges who will hear a case, and then they will vote, and whoever gets the majority of the judges to vote their way, that's who will win that case. But once cases make their way up to a federal district court level, these decisions can have constitutional implications, and so that's why we don't leave it up to just one judge to make these decisions. Instead, we have a panel of judges kind of debate the merits of the case, the constitutionality of the case, and then vote on a decision. The federal appellate courts would be the next step up. So any federal trial court cases that are being appealed will go to the federal appellate courts, as well as cases coming out of the states that have gone through all the different levels of state courts. They will then enter into the federal system. Only about 20% of lower cases will make it to this level. Like we said, there's 11 regional circuits, the DC circuit, which is also kind of its own thing. And then, like we said, the decisions made at these levels, they can be final. If, say, the federal appeals court makes a decision on the constitutionality of an issue, and the Supreme Court does not decide to review that case, then that becomes the final word. But if the U.S. Supreme Court decides to hear an appeal coming out of the federal appellate court system, then their decision will be the final decision made in that matter. Now, the U.S. Supreme Court, the federal court that gets the most attention, and this is all of the current judges in this background picture except for one, Justice Kennedy, who is this gentleman here, is no longer on the Supreme Court. He was replaced by Brett Kavanaugh. The court is referred to by the last name of the Chief Justice. So our current Chief Justice is John Roberts. So this court would be referred to as the Roberts Court. Supreme Court justices are appointed for life. They go through a confirmation process where the president will recommend someone to be appointed to the Supreme Court. They go through a Senate process where they are interviewed. Their background is, investigated. Their record as a judge is investigated. Then they go through these Senate hearings where the senators can question them. If you paid attention with Brett Kavanaugh, you saw this process. And then the Senate votes to confirm them. And so if you want to make it to the Supreme Court, you're recommended by the president, but you're confirmed by the Senate. Justices serve for life, though. And the idea behind that is that the Founding Fathers believe if the Supreme Court justices serve for life, they didn't have to worry about being elected, then they wouldn't get involved in partisan politics. Now, we know that all of these justices come to their position with a political point of view. So it's impossible to expect them to not be somewhat partisan, but we do expect them to hear cases fairly and decide them based on the merits of the case and the principles of the Constitution. Lots of justices have been questioned about, doing this the proper way. And then in the process of being confirmed, there is a mechanism called senatorial courtesy, where a senator can essentially request that a nominee be withdrawn from the president's recommendation because that judge may be from that senator's state, and that senator does not have confidence that they can do the job. If a senator objects, typically a president will comply. Our current president, not so much. But typically presidents are going to nominate justices because of their ideology. So if you have a conservative Republican president, they're going to appoint conservative Republican judges, and vice versa with liberal presidents. But they also look at their age, their experience, their previous positions they've held, the decisions they've made in the past, and things like that. One of the biggest criticisms of the Supreme Court has always been this idea of diversity. Today, we actually have one of the most racially and gender diverse courts that we've ever had. We have one African American justice, one Latina justice. Justice Ruth Bader Ginsburg is Jewish. Samuel Alito is Italian. And we have the most women that we've ever had serving on the court today. Where they are not diverse is their background. All of the judges had come from Ivy League schools. So most justices that get appointed to the Supreme Court, they're not individuals who have gone to public colleges and universities and things like that. They stick to these Ivy League graduates that come out of Yale and Harvard for the most part. There's always that perception that those schools are better and they produce better, well-educated individuals. I don't believe that. I think that's bullshit. So that's one of the criticisms as well, is that because they come from these elite backgrounds, they really can be disconnected from the average American and the decisions they're making and how those decisions are going to affect the average American citizen. Judicial review is the most important power that the court has. This power gives the courts the authority to review and declare the actions of the legislative and the executive branch unconstitutional. This power was established in Marbury versus Madison, which is a case I'm sure you've read and heard about, if you've taken political science before. So we won't go too far into it. But essentially, in this case, it was requiring an incoming administration to recognize the appointments of the previous administration, and they refused to do so. And so one of the people who was given an appointment is Mr. Marbury, and he brings the case against Madison, who's part of the incoming administration. And the court says that they don't really have the ability to make the new administration honor this previous administration's appointment, but they do reserve the right to, in the future, declare actions of the other two branches unconstitutional, and this is what makes them part of the checks and balances system. The supremacy clause we've talked about a lot this semester, but it applies to the Supreme Court as well. So when the Supreme Court makes a decision, it overrides state law, and that decision has the authority and enforceability of law. So a good example here, if you remember back in 2015, when the Obergefell versus Hodges case was decided, this was the case that legalized gay marriage in the United States. And so we had many states that had laws on the books that made gay marriage illegal. We had many states that had laws on the books that made it legal. And so the Constitution, like we've said, doesn't like this type of situation. Citizens are supposed to have the same rights across the board, no matter what state you live in. And so the court rules in Obergefell versus Hodges that, using some precedents from other cases, that yes, marriage between two consenting adults of the same sex is permissible under the Constitution. So all those states that had laws banning gay marriage, this decision overrides those laws. So once the Supreme Court issues a ruling, that becomes the law of the land. These other two terms, don't worry about tort cases too much, but common law is just when the Supreme Court looks at precedents and uses that to make new law, kind of like they did in this case. They looked at the Loving case about interracial marriage. And so the principles of that case heavily informed Obergefell versus Hodges. Now, when can you bring a case before the Supreme Court? Well, first of all, the court has to agree to hear your case, and not many cases will ever make it to the Supreme Court. But to bring a case, you have to have standing, which means that the issue that you're bringing to the court directly affects you. So if we look at, say, abortion, a man really could not bring a case to the court over the issue of abortion and how they are affected by abortion because they are not a woman. So Roe versus Wade has essentially decided that women have the right to choose to have an abortion. So unless someone is directly affected by this, they don't have the standing to bring this case. So you can't bring a case on behalf of somebody. You have to be directly affected. Mootness means that a case is pending, it's waiting to be heard, but a decision in another case essentially makes that case irrelevant. So if we had other gay marriage cases waiting to be heard when Obergefell versus Hodges was decided, then essentially they became moot, which means that the ruling in Obergefell decided that issue, and so those cases no longer needed to be heard. Rightness is when a situation has reached a point where a decision has to be made. There's a couple of ways that this can happen. The issue with gay marriage is one of them, where we had some states with one law and some states with another law. Like we said, the Constitution is not the intention of the Constitution, so the court has to step in and settle this issue. This is why I say that I believe the legalization of marijuana could reach this point as well. The other situation where this can happen is, let's say that we have a case in District 9 and we have a case in District 5, and two federal courts come to two different conclusions. Only the Supreme Court can settle that issue because their authority is higher than both of those district courts. So those are some good examples of rightness when a case has to be heard and decided and the Supreme Court has to intervene. To decide to hear a case, the justices essentially vote among them and they issue what's called a writ of certiorari when they're going to hear a case, and that means at least four of the justices have voted to review the decision of a lower court because they believe they need to clarify and resolve that issue. In the Supreme Court, the Solicitor General is a government attorney that represents the United States. Now, depending on who the president is, the Solicitor General is typically going to represent that president's point of view because they are also appointed by the president. So if you have a conservative president, the Solicitor General is probably going to take the more conservative side of the argument, and vice versa for a liberal. And then amicus curiae briefs can be submitted by anybody who has a interest in the case that's being heard. This can be lobbyists, this can be interest groups, this can be individuals, religious organizations, whoever. They can submit briefs to the Supreme Court as well, essentially trying to make arguments for why the court should reach the decision they want them to reach. So it gives the public some access to the court to try and influence their decision as well. Now, how does a Supreme Court hearing work? Now, the attorneys that argue at this level, they are the best of the best. And they have to be because this is a very stringent and strict process. So before the hearing ever takes place, there's going to be preparation. The attorneys put together briefs, which are documents that explain why the court should rule in their favor, and they typically are citing precedent from previous cases, citing the Constitution, all of that kind of stuff, making their argument to the court in written documents. Now, when the trial starts, the attorneys representing either side will make their case to the judges directly in oral arguments. Each side only has 30 minutes to make their argument. So you've got to be on top of your game and know what you're doing. And within this 30 minutes, the justices can ask you questions, they can interrupt you, they can ask you to clarify, and that is included in your time. So this is a very strict process, and they do cut them off at 30 minutes. You don't get overtime. Once the oral arguments have been made, the trial part is over. And then it goes to what's called a conference. And the 9 justices will meet a couple of times a week on Wednesdays and Fridays to discuss cases. And they essentially are trying to convince each other that they should vote a certain way, change each other's mind. And this process we don't see. This is private and behind closed doors. Once the judges feel that they've done everything they can do as far as arguing the merits of a case, they vote, and of course the side with the majority of the votes wins, and there are opinions that are written. The winning side, one justice will write an opinion called the affirming opinion, which explains how the justices came to the decision they did, why they decided the case the way they did, and that decision carries the weight of law. But the minority opinion is called the dissenting opinion. And a justice will also typically write a dissenting opinion explaining why they think the other side got this wrong, why it's incorrect, and they lay out their arguments as well. And this is important because many times cases having to do with this issue may come up again. And so the dissenting opinion is a good place for an attorney in the future to start to build their argument if this type of case comes up again. Now, there's also different philosophies about the role of the Supreme Court. Because the decisions of the Supreme Court carry the weight of law, they have a lot of responsibility and a lot of power. And some people disagree with this. They believe that because the Supreme Court justices are not elected, that they really shouldn't have the power to make law in this way. But they are appointed by people that are elected by the citizens. So that kind of, it's a response to that question. But there's two kind of perspectives on how the judges should make their decisions. One is what we call judicial restraint, and this is typically favored by conservatives. This philosophy says that the justices should never go beyond the words that were written in the Constitution, that they essentially should only interpret the Constitution as it is written and use that to make their decisions. Judicial activism is the other side of that coin, and this is typically more of a liberal mindset. And judicial activism essentially says that the justices have to go beyond the Constitution because the Constitution could not have predicted the issues that our society is dealing with today. If we think about the founding fathers, there's probably a good chance they never thought about things like gun control for semi-automatic weapons. They never thought about gay marriage or abortion or any of that kind of stuff. And so if we're sticking just to the Constitution, then the Constitution doesn't say anything about those types of issues. So judicial activists believe that the justices have to take the principles of the Constitution and apply them to societal issues of today. Ideally, though, decisions aren't supposed to reflect partisanship. They are not supposed to be made to make a certain administration happy. But again, it's hard to separate a person from their beliefs as well. Now, there are some limits to the court's ability to make law. They can't just exercise their power independently. The Supreme Court cannot make a law. They have to wait for a case pertaining to a certain issue. Only the legislature can make a new law. The courts can only grant aid to individuals, not broad social classes. So what this means is, let's say in our gay marriage case, that those individuals, in addition to the case they brought, were also suing for financial compensation. Well, because the court sided with them, they could award financial compensation to the two couples who were part of the Obergefell versus Hodges case, but they could not give monetary compensation to all gay couples in the United States. So they can only give financial compensation to people who are a party to the case itself. Courts do not have enforcement capabilities. This is one of the problems with Supreme Court decisions. We talked about this when we talked about Brown versus the Board of Education. The court ruled that schools needed to integrate, but essentially had no power to enforce that decision. It wasn't until the Civil Rights Act that was signed by President Johnson that he gave authority to the federal government to withhold federal money to the states until they decided to integrate their schools. So the Supreme Court depends on the executive and the legislative branch to enforce their decisions. And then the political makeup of the court is subject to the will of the president and the Congress. So the Supreme Court is always shifting because we get new justices coming in. As justices step down, the next president or this president is going to appoint someone who is in line with their political makeup. So we typically have a pretty ideological diverse Supreme Court, and because today they do vote down party lines pretty often, it's really the side with the most judges that typically wins. And so on today's Supreme Court, we have 5 conservatives and 4 liberals, and the conservatives have had quite a few victories under President Trump because he was able to appoint that conservative majority. Now, some revolutions or changes in the Supreme Court system. Changes to standing allows for almost any person or group to challenge the actions of administrative agencies and bring a case. So if you are a citizen of this country and you feel you have been wronged, your rights have been violated, especially by the government itself, you have standing to bring a case. But you still have to have the evidence to back up your case. Class action lawsuits. Some of you may have seen these, or maybe you've gotten those emails about like class action lawsuits you may be a party to. This way, entire groups of people with a common complaint can bring a case together. And if you have a lot of people who are a party to it, it kind of strengthens the argument for that case to be heard because a lot of people are saying that they have been affected by this issue. Also, monetary compensation can be awarded to more people at one time. And then structural remedies essentially allows for the court to maintain jurisdiction until its ruling has been implemented. So, like in the case of Brown versus Board of Education, the court gets to maintain jurisdiction until all those schools have integrated. So they're not giving up the ability to call those parties back, question them, ask them why they have not done this, call on the legislature and the executive to, use some kind of punishment, that kind of thing. So it's their ability to follow through and make sure their decisions are enforced.